Bună ziua și bine ați revenit la ora arbitrajului. Așa cum spun de fiecare dată, încerc să păstrez emisiunea cât se poate de atractivă, oferindu-vă o varietate de speaker și o varietate de subiecte dintre cele care sunt de maxim interes. Cred că și de data asta veți fi de acord cu mine că subiectul ales pentru astăzi este unul de maxim interes și, dacă nu mă înșel, este o premieră pentru piața din România, pentru că, după cunoștințele mele, nu mai există niciun fel de interviu de acest tip cu un reprezentant al unei firme de third party funding, al unui funder, activitatea despre care vom discuta astăzi. Pentru că invitatul nu este român, vom trece ca de obicei la limba engleză. So, the topic for today is third party funding, and we have the chance to have as our guest Mr. Adrian Chopin, who is managing director with Benck Walk Advisors. For people who are familiar with international arbitration or third party funding generally, Benck Walk Advisors is one of the leading worldwide companies in third party funding. Adrian, welcome.
Thank you, Cosmin.
Welcome to Bucharest, Romania, and welcome to Arbitration Hour. For Arbitration Hour, we are sure that it is your debut. Is it your first time in Romania?
It is, yes.
Okay. How do you find Romania? This is my general first question for guests who are visiting for the first time Romania.
I have brought my wife and child with me, and we're all enjoying it very much. We've had a bit of trouble getting an Uber, but otherwise it's a lovely city. Thank you very much.
Just Bucharest so far? Or?
Just Bucharest. So.
Okay, and you plan to visit something else, or you don't have
No,
time?
we're in Bucharest the whole week. So.
Okay, I think Bucharest is sufficiently attractive as a destination for 1 week, so I really hope you're going to enjoy the rest of your stay here, even if I know that you have also some business to handle in Bucharest. You are not only for fun.
Correct.
Okay, now let's get back to our topic. We have 45 minutes to say as much as it can be said and explained about third-party funding. First of all, please introduce you personally. The general politeness rule of journalists says that the host should introduce the guest. I believe in this case it is more appropriate for you to introduce yourself and your company, and then we move to the business of third-party funding.
Thank you. So my name is Adrian Chopin. I began my career as a lawyer at Allen & Overy, but I was never a litigator. I was a structured finance and derivatives lawyer. And I then became an investment banker, which I did for about 10 years. And I moved into third-party funding in late 2015, when I set up a litigation funding business for one of my clients out of Deutsche Bank, called Orchard. And I built that business for 2 years, and then I launched a new dedicated litigation funding business out of London for Benck Walk, which was a company founded by 2 American class action attorneys called Stuart Grant and Jay Eisenhofer. So I joined them and launched the London business in October 2017. So we've just concluded our first full year. So Benck Walk is a full-service litigation funder. We provide third-party funding across a wide range of cases, from relatively small investments as small as $1 million up to very large investments, including north of $50 million. Third-party funding is a means of financing litigation or arbitration claims that might otherwise not be funded, or a means of de-risking the funding of that litigation or arbitration. What does that mean by de-risking? Well, the funder typically pays the legal bills of his attorneys and other representatives and the out-of-pocket costs of running a piece of litigation or arbitration. Sometimes the third-party funder may pay only a portion of those fees, sometimes he may pay 100% of them. And in return, if the litigation or arbitration is successfully concluded and recovery is made, then a portion of those recoveries are paid to the funder.
Okay, let's stay a little bit on general issues, because I think they are interesting for all the people watching us. Your company, Benck Walk Advisor, when was it set up? Do you happen to know?
We launched the business in October 2017. So
the company itself is sort of a new player. It's not.
Yes, relatively. Although all the participants in the business have substantial experience.
Exactly. But what about third-party funding? When can we discuss about the official birth of this type of service? Not accidental acts of funding a case or another.
Yes.
The business, the industry that.
Yes, so dedicated litigation funding has existed for a little more than a decade. The industry really began in Australia more than a decade ago and has really begun to reach its fullest maturity globally over the past 5 or 6 years. You still see a significant number of new entrants, new capital coming into the market every month. And there is still a great deal of development to be seen in the business, but we're certainly reaching an interesting stage where new players are entering and new models are being tried.
So, coming back to your answer, the conclusion would be that the actual industry or business of third-party funding was born somewhere between 2005 to 2000.
Yes, I think that's right. The business of funding litigation in ways other than simply paying your own legal fees has existed for longer. It really grew out of insolvency, where an insolvent or bankrupt claimant, usually an insolvent company, needs a way to pursue litigation in order to return assets to the estate. And that business has been run historically mainly by lawyers taking all their fees at risk, so a no-win, no-fee structure. And possibly with the liquidator or the insolvency practitioner investing some additional money to cover the out-of-pocket expenses. That's really the birth of that's the genesis of this industry. Since then, litigation funders have stepped in and taken over some of that business, but also have expanded the product range. So although it began as a product primarily for insolvent or bankrupt claimants or plaintiffs, now the product is widely used by solvent claimants or plaintiffs.
Yeah, I think I'm not wrong when stating that the need for funding for various reasons and to various extents has been eternal and ubiquitous. I don't think this is a wrong statement.
I think that's right.
Okay. The question, which may be interesting, is what do you think that represented the trigger for making isolated cases of financing one way or another or supporting the effort of undertaking steps in a dispute resolution mechanism to the articulated idea of an industry and of some players providing the exact services in a crystal clear manner? Because there is a gap, and the question would be, it's one of my curiosities, what could have been the trigger?
I think it's difficult to isolate a single event, but an important change, particularly in common law jurisdictions, was a change of legislation in the UK. Previously, the provision of capital to support somebody else's litigation or arbitration in return for a share of the winnings was illegal until the 1960s in the UK. In theory, it was a criminal offence. And even certainly more recently, the contracts ran a serious risk of being unenforceable. So there was a legislative change that drove the industry in the UK. But really, I think there has been a growing familiarity with the business, partly as a result of the legislative change, but also partly a recognition that this is a means of exploiting an asset that otherwise might not be exploited. You wouldn't, for example, buy a car or a house often without considering the possibility of taking financing. It's not that you think it's an inefficient use of your money to pay interest to the bank. You often think it may be more efficient. And similarly, corporates are beginning to understand that actually these pieces of litigation are assets like any other and are susceptible to interesting financing structures, and litigation funding is a key portion of that solution.
So, very interesting remark, at least as far as UK is concerned. A decisive intermediary step was the change in legislation that at least created the possibility, left room for this kind of development.
Yes, and it varies from jurisdiction to jurisdiction. So it is likely that the growth of litigation funding was somewhat more constrained for a long time in the United States, simply because lawyers were very often filling the need by taking all of their fees at risk, so doing a pure no-win, no-fee arrangement, which was much less common in the UK and Australia and some other common law jurisdictions.
But you mentioned already a couple of times about UK on one hand and on the other hand Australia and the United States. Can we identify, can we spot a certain jurisdiction as the homeland initially for funding, or it was a parallel evolution?
It began in Australia. Its earliest formation was the earliest formation of dedicated litigation funding businesses, so professional providers of third-party funds were Australian, but and that's to distinguish the ad hoc providers of funding from the dedicated providers of funding. Ad hoc provision of funding, whether for commercial gain or simply for charitable or other interests, has existed probably in all jurisdictions for rather longer.
And today, as we speak in 2019, which is or where are located most of the funders? They are in Europe, in the United States, in Australia. Where are they?
They are, for historical reasons, still primarily Australia, UK and the US. There's huge growth in all markets. We've seen funders launch, a number of funders launch in continental Europe, France, the Netherlands, South America, all sorts of different jurisdictions have seen a growth and will continue to see growth. And we'll continue to see specialisation, including geographic specialisation and area of law specialisation, with some funders choosing only to specialise, for example, in intellectual property or only in investor-state arbitration. And I think that's healthy and a necessary development for the market. A different perspective would be, which are, geographically wise, the jurisdictions that are open to third-party funding? Where are the cases that are funded coming from? Still primarily North America is a big driver of volume of deployment, but I suppose perhaps just because of historical familiarity, it has tended to be the common law jurisdictions. But actually, there's a certain illogicality in that, because the common law jurisdictions have always had this concept of champity, which is the rule, or was the rule, that meant that many of these agreements were unenforceable or even illegal. Whereas, for example, many of the Napoleonic jurisdictions simply have no issue at all with the concept of third-party funding for litigation, and those contracts have been enforceable much longer. So logically one might have thought that the industry ought to have reached its fullest extent, say in continental Europe. That hasn't been the case, but we really are seeing huge growth in those jurisdictions.
Another general question, but of utmost importance, I believe, for people to understand the exact legal perspective on this type of financial service. I think it is a mixture of legal and financial service, or
yes,
yeah. Is this sort of product regulated, and if yes, by any law, by legal provisions? And it is obvious that we discuss about truly international perspective upon things, because the funders are located in London or in the United States. This is less relevant, because a funder would usually deal, probably day by day, month by month, with claims arising from various jurisdictions, which make the entire process truly international.
Yes.
And the question is, from your perspective as a funder, you are regulated, or which are the legal thresholds, the ambit that you feel you have freedom to play within?
So generally it will depend on the forum in which the litigation or arbitration occurs as to whether the contract itself, the contract of funding, attracts regulatory or legal scrutiny. Some jurisdictions, as I mentioned, have either current or had historically prohibitions or restrictions on litigation funding. Generally, many of the common law jurisdictions are now comfortable with it, and as I mentioned, many of the non-common law jurisdictions have always been comfortable with the premise of providing third-party funding. In terms of other forms of regulation, there are some voluntary self-regulatory organisations of which some funders are members, and those promulgate rules about what ought and ought not to be in, for example, a funding agreement. But there's not. It's not. I can't say that there is a global system of regulation of litigation funding. Each jurisdiction is taking things somewhat differently.
So, trying to take it step by step and piece by piece. One of the perfectly legitimate concerns for the funder are potential legal obstacles within the jurisdiction that generates the dispute.
Yes.
If you have, I assume, please correct me if I'm wrong, if you have either a legal provision expressly prohibiting it, or legitimate question marks as to the enforceability of the agreement, you would politely say no, because you cannot step into such a
Correct.
grey legal issue. On the other hand, if there are no legal obstacles, then from your perspective the case is theoretically eligible for funding, correct?
Correct.
Okay. On the other hand, coming back to the industry, it is rather a self-regulated industry, because it has become strong enough and with numerous players, so that the concern of auto-regulation occurred, rather than regulated by national laws or international soft law or class. Okay. Do you agree with me that one day, and I would rather say sooner than later, either the European Union or other significant international players may want to step in and regulate this kind of business?
Possibly. I think regulation could come from two sides. Do you want to regulate to protect investors in the business? I suspect the industry is not a prime target for regulation on the investment side, because at least to date almost all of the investors have been very sophisticated financial players. That said, there are some new investors, some new funds who are raising capital, for example, online, and that is probably the subject of existing regulation and maybe the subject of specialist regulation for this business. Then you may choose to regulate the business for users of the product. So should your borrower be protected by regulation and legislation? I think there's a less obvious case than for some asset classes. But again, it will go jurisdiction by jurisdiction. I think on the whole, at the moment, the pressure for regulation that we see most sharply is in the United States, and at the moment the focus has been on whether there ought to be disclosure of certain terms of litigation funding arrangements so that the defendant has a better picture of how his opponent is funded. I don't see a pressing reason for regulating a contract that provides funding to a borrower who is advised by a good attorney, which will typically be the arrangements that most litigation funders will be entering into. His attorney acts as a natural brake on excesses that might otherwise occur. I think to date the industry has really taken its responsibilities very seriously, but it's not impossible that as the industry grows, perhaps some new players enter who operate a different business model that perhaps increases the demand for regulation, but at the moment I don't see the need as a pressing one.
In international arbitration, in the last probably 7 to 10 years, but more and more often in the last 5 years, the topic of third-party funding and consequences, especially in connection with conflict of interest and disclosures that are supposed to be made by the arbitrators, these are, I would say, hot topics.
Yes.
Probably either at the level of arbitration courts, or even if we make reference to soft law instruments that are of large use in international arbitration, a sort of partial regulation as far as the conflict of interest is concerned will occur, or I think we can already discuss about some steps in this respect.
I think that's a much greater risk in, for example, arbitration, where arbitrators will very often have private practices and won't be full-time arbitrators. I think the need is less pressing, and the risk of conflict of interest is less pressing where you have professional full-time judges. And as to the need for disclosure in arbitration where there is a possibility of conflict of interest, yes, I can see there's a reasonably compelling argument that there ought to be some form of disclosure of the method by which a claim is funded where there's a real risk of conflict of interest.
But again, from your perspective, I'm not talking about the perspective of a party, claimant or respondent in a case. I'm not discussing about the need for neutrality of an arbitrator and the general perception of an arbitrator being neutral and biased. I'm talking from your perspective, funder's perspective. Is there any significant difference between the public statement, this case is funded, I go in press and say I will file a claim which is funded, so everybody knows it, or I put it on paper on my first page of the request for arbitration, and the, let's say, grey or even obscure situation of a funding agreement which for various reasons is kept in the drawer. Is there a difference?
From our perspective, we are normally happy for our funding arrangement to be disclosed, and as you imply, there are some instances where we think that can be advantageous. One of the most interesting situations in which we can provide funding is where there's a David and Goliath situation. The plaintiff or claimant has a very valid claim, but a very well-resourced defendant, and the plaintiff or claimant simply wouldn't be able to pursue his claim without our money. We level the playing field. That's one of the really large potential benefits of third-party funding. And in that situation, you may well consider there to be a large advantage in setting out clearly a statement that we're funded, we now have the resources to take this claim to conclusion, so that there's less merit for a defendant in simply hoping that the plaintiff or claimant will fall over for lack of funds. So generally we'd be happy for our agreement to be disclosed, and we would normally take guidance from the attorneys running the case for their client as to whether tactically it's advantageous.
On the other hand, at least now I step aside a little bit, and I'm not staying in the shoes of the funder, but in the shoes of the parties. One can easily imagine cases where it is not tactically wise recommended for a claimant to disclose that the claim is funded. For the perspective upon the case, for the reaction, the predictable reaction of the respondent, but again, these are arguments, pros and cons,
Yes.
for the parties, not for the product itself or for the industry of funding.
Yes, I think that's right. And as I mentioned, our typical approach would be to say, what does the attorney running the case think is the appropriate course of action as regards disclosing or not disclosing?
Yeah, and one final question under the umbrella of the general questions concerning the business. I see on your business card that you are located in London, and my question is, as of April 1st or April 2nd, is the third-party funding business of the companies located in London going to be affected by, apparently, the imminent Brexit?
That's a very good question, and it may depend on whether or not we have a no-deal Brexit or whether we have the backstop.
I think we're going to wait for the answer until 28th of March.
I think generally will it impact our business? I think wherever there is uncertainty, there is usually opportunity in the financial sector. A no-deal Brexit might result in significant legal uncertainty, which may in turn give rise to disputes, which may need funding. But more generally, will the UK continue to be a jurisdiction that parties want to use to resolve their disputes? I suspect it probably will, even if we end up with a no-deal Brexit. And even if it won't in the long term, which I think is unlikely, the fact that so many contracts have English governing law or London stipulated as the seat, that won't change overnight. That will be a process of several years while the contracts work themselves through. All those contracts have already been written and the disputes may yet arise. So I don't think we'll see a sort of overnight catastrophe for litigation funds in London. And actually I think there's at least a possibility of opportunity.
Okay. Now let's be even more specific about how does it work. Your company today, as we speak, is financing what types and what size are the claims that you are financing?
So we typically finance claims, single claims of at least $10 million claim value, and we might provide a minimum of $1 to $2 million of financing. In terms of smaller claims, the solution tends to be that there are some dedicated third-party funders who will fund rather smaller claims, or these things tend to be bundled into portfolios of one form or another. Either a corporate client may have multiple claims over a period of time, and those can be bundled together to make it efficient to finance, or an attorney may represent a number of different clients and may over a course of years build up a book of multiple small claims, and those can then be financed between the third-party funder and the attorney directly.
Okay, but this is clear enough about the size or the value of the claims. Can it be any type of claim? I mean, if somebody steps in your office and they have a collective labor claim of 20 million euro, are you willing to finance it?
Yes, in principle. So there are a number of features that make a claim fundable, but generally there needs to be some form of real value at the end of the process. For example, it wouldn't obviously be the case that a claim for defamation or libel would be fundable. That's relatively rarely the case. Not impossible, but pretty unlikely. And a claim for some form of judicial review or declaration from the court, declaratory relief, it may be fundable depending on the circumstances, but generally that's less likely to be the case than an obvious monetary dispute or dispute over an asset that has real value or dispute over intellectual property where real value can be unlocked. So a source of value that can ultimately be shared in some form with the third-party funder is normally an important prerequisite. And there are some jurisdictions that would be inherently harder to fund.
So, provided that the conditions that you have briefly described are fulfilled, any claim large enough to fit in for your criteria can be financed. I know from practice that the typical client for funding is a claimant who is seeking to recover some money.
Yes.
I would say this is in 90% of the cases or even
Yes.
more. If all the other conditions are met, can a respondent resisting as a respondent in a, let's say, commercial case, resisting a 500 million euro claim eligible to be funded?
Yes. So defence funding, as it's
Yes.
known, is perfectly possible. The obvious point for claimants is there's usually an asset or a sum of money in dispute, and the claimant currently holds nothing, but will be paid, he hopes, by the respondent on a win. And that's the obvious source of value to divide between the funder and the claimant on a successfully concluded funding
But for the respondent,
for the respondent, there may be that situation. You may be disputing an asset ownership, but it's less likely. More often, you as the respondent are trying to avoid making a payment. So the way defence funding has to work is the respondent will end up having to pay some portion of the remuneration due to the funder on win. So it will be structured, unlike claimant funding, it will have to be structured almost always as an obligation of the respondent or defendant to make a partial payment to the funder on a successful conclusion. And then the trick is, how do you define successful conclusion? And that's normally a process of arranging the possible outcomes and setting cut-off limits for where certain payments are made to the funder.
Mm-hmm. Now, moving back to the usual typical situation of the claimant seeking to recover some important amounts of money. What is the role, if any, of the solvability of the debtor? We contemplate the perfect legal system, the rule of law is sacred and saint, but the question becomes, will the very likely successful claimant be able to actually recover the money, looking at the not very healthy status economically wise of the respondent? Is this a matter of concern for you?
Yes, the collectability is an essential component of all funders' assessment of whether a claim is fundable. And I think that is a healthy attribute of funders' analysis that is brought to claims. I think historically there have been examples where claims, if a claimant had stopped to think about whether a claim was worth pursuing, he might have concluded, actually, I'm probably going to win this, my lawyer's telling me I'm going to win, but am I going to get any money at the end of it? So funders very often force that process to occur much earlier in the claim than might otherwise have been the case. And incidentally, it's the same with experts' reports. Most responsible funders will, relatively early in a claim, a piece of litigation or an arbitration, will insist on some work from experts to ensure they've got a viable claim. Historically, there has been a real risk that lawyers have run a claim and only late in the process have engaged the experts, and at that point have concluded that their claim wasn't as valid as they initially thought. So funders will often result in a front loading of some work. They ought to be willing to pay for it, and they usually are willing to pay for it. And I think on the whole that can result in more robust claims, both from an expert causation and quantum perspective, but also from a recoverability perspective. That said, there are also interesting products that funders alone or together with insurers can provide, including that funders are, in certain instances, able to arrange or to provide insurance for the risk of collectability. so that if you win, say, a piece of investor state arbitration and you haven't been paid on your final award within a matter of months, then the insurer will pay a lump sum of capital, and then the insurer will take over the enforcement process. And if the insurer recovers additional cash, that will also be paid over to the claimant. So there are financial solutions to some of these problems, but you're absolutely right, it's a key component of the risk assessment.
It is a key component. And let's assume that, I suppose in certain cases, you don't have the option of insuring the risk of not recovering the amount. I imagine that not all the cases can be insured.
Not all cases can be insured, correct.
In a
That'll
case
be a risk
like
assessment
this,
process.
the claim looks great. It is obvious it is going to be admitted to a certain extent, but the perspective of actually recovering anything is totally unclear. It's grey,
Yep.
purely grey. Is this a prerequisite analysis that you make preventing or allowing you to go ahead in financing the project, or you accept to finance it and then you continue to be focused on...
It very much depends on the claim, but most funders will be prepared very early on to invest some capital, say in asset searching, and they'll engage specialist asset search companies to locate available assets of the respondent. And in the case of a state, there are some states where it's very difficult, but usually you'll be able to find assets.
But for a private company, it is always possible to...
It's always possible that it has no assets.
Yes.
Generally, for those private respondents or private defendants who are unlikely to have assets, it's normally relatively obvious that you're not going to be able to recover anything. But it can be that when you engage a professional asset search company, you locate hidden pockets of assets that nobody had expected.
Mm-hmm. Okay, and another question of maximum interest for people watching us would be how does it work in terms of internal process that eventually leads to the conclusion, yes or no, we are willing to finance a claim. I imagine a lawyer steps in your office and he or she says, look, the 2 million pages of my file, everything is perfect, you just need to review it and you are going to say yes and
yes.
Hug me enthusiastically for bringing you such a claim. Then what is the internal process for you in assessing the claim?
So each funder will run its own process and there will be slight differences between different funders, but generally all funders will undertake a fairly rigorous financial assessment of the case, including points such as collectability. They'll do some financial modelling, they'll work out various pricing options, and they will normally propose a price and a structure to you and to your client. Once that's agreed, a process of due diligence will occur, again further financial due diligence, but also critically the legal due diligence on the merits of the claim. And some funders conduct that entirely internally, some engage external resources, and some use a combination of both. And that will be a process typically of reviewing the documents, but also often interviewing any key witnesses, certainly interviewing the attorneys running the case. And at the conclusion of that process, which may be a matter of weeks, or in some cases may be longer, the funder will say, yes, we're through the due diligence and here's a document, and generally once the process is documented, then the money begins to flow.
Mm. So it is actually a very thorough assessment process using dedicated resources specialists, either they are in-house or they are counsel law firms that they usually work with the funder. And from this perspective, it becomes clear that green light coming from a funder means that the funder himself reached the conclusion that the claim is viable and the likelihood of success is high rather than limited.
Exactly.
This is one of the, on one hand predictable, on the other hand interesting in terms of difficult to assess consequences. At one international conference a few years ago, somebody raised the following issue. What is the exact impact or the invisible internal thoughts that an arbitrator may have when understanding exactly that a finance claim means a claim that got green light from the funder, who may be the best funder using the best lawyers in town for making the internal assessment. And this one of the, let's say, cons against the idea of, I don't know, encouraging or disclosing third-party funding. Which, I mean, the remark in itself is correct, and on the other hand, it is complicated to try to assess the weight of this kind of situation.
Yes, I think that's fair. I think an arbitrator or a judge learning that a case is funded may feel, well, this funder is likely to abuse
this is a serious
very
case.
specialised resources.
Yeah.
I suspect there wouldn't be many arbitrators who would say, oh, and therefore it's a definite winner for the the claimant. But I think on the whole it can lend a certain weight that the funder's taken this seriously.
You are present in Romania for an international arbitration event.
Yes.
Dedicated to international arbitration. It is, I think in the last 3 or 4 years, I haven't seen any serious international event without the presence of a funder, of a representative of a funding company. The exact question is, what do you hope from Romania? What are you here to offer to Romanian players?
So I think international arbitration is a very important area of business for almost all funders, and I think there is, we are seeing a lot of growth, particularly in investor-state arbitration, and to take the example of the panel on which I'm sitting, energy disputes in particular, which are more often than not are investor-state disputes, are an area that has seen a significant deployment of funding over the last 5 to 10 years, and I think we will continue to see more of those, including coming out of Romania.
So Romania is a quite active market, both generally for dispute resolution and for international arbitration. Maybe surprisingly for a country which is not so large but represents one of the largest East European countries. Romania is one of the top 10 providers of international arbitration cases, for example, to ICC and to other local courts. So Romania is a living and vivid jurisdiction. Leaving aside this part, the economical reality makes or leads to many cases, classical dispute resolution cases before ordinary courts, or even arbitration cases, where the stake is not so high. The so-called, I don't know, not necessarily minor, but at least from a funding perspective, small claims. Small meaning a $5 million claim. I have witnessed personally a case where a client of mine witnessed desperately the time bar term being accomplished because he was not able to finance an ICC case. He simply didn't have financial resources, even if years ago the company was healthy enough to support this kind of effort, but not when the moment, the essential moment has come. The question would be, considering the dynamics of the field, the continuously growing number of players, can Romanian companies who would consider for sure the option of funding for their claims, let's say under $10 million claims, which are under the threshold usually, can they hope one day for a third-party party funding company to provide these services, not necessarily in Romania, but to provide it?
Yes, I see no reason why not. We're already seeing the growth of specialist litigation funders who focus only on small claims. To my knowledge, none of them has yet looked at Romania, but in principle there's no reason why those outbound claims in the ICC, say, wouldn't be eminently fundable. And even if Benck Walk wouldn't, for example, look at a claim for funding as a single case that was very small, there's no reason why we wouldn't fund, and we have already funded, portfolios of these claims. So, and that can either be because we fund an attorney who runs a handful of these claims with some of his fees at risk, and so we provide financing to the attorney against his fees, and he takes a success fee if the claims conclude successfully. Or alternatively, an individual corporate claimant who has 3 or 4 or 5 claims over the course of a number of years may also be fundable on a portfolio basis.
But on the other hand, looking at the tendency and the continuously growing number of players, I think it is not wrong to say and to hope that it is just a matter of time until...
I think that's highly likely.
Yeah. Adrian, thanks a lot for your explanation. It was a very interesting and vivid and enjoyable discussion. I'm pretty sure it was very interesting for people watching us, and I wish you rest of your stay in Bucharest as enjoyable as possible, and I hope we are going to meet soon in Bucharest or somewhere else in a few years, and I hope that our discussions and conclusions then are going to be finalized with a very optimistic conclusion as to the tendency or the larger use of funding generally in dispute resolution, because my personal view is that it helps a lot, and it is the more the service grows, the bigger and more important its advantages are going to be for the parties, and this is the most important part of it. The parties to be able to play properly their cards when they are involved in sophisticated dispute resolution or arbitration or whatever alternative dispute resolution mechanisms.
I couldn't agree more. Thank you very much.
La revedere, rămâneți cu bine.